Cabarrus County School District is facing two lawsuits this morning. The first case involves a former J.M. Robinson High School teacher accused of restraining a student with special needs by sitting on him and allegedly choking him. The alleged incident happened in October of 2024. The family claims the district was negligent in ensuring their son's unique needs were met and that the former teacher violated his rights.
I want to go back, similar to how you just mentioned that case, trying burden proof evidence. What do you have to show? Let's go back to the first case. When you've got a possible nonverbal child or cognitively impaired somehow, how do the plaintiffs, what is the evidence, the burden of proof when you're trying to say, hey, this is what happened to my child, if you can't ask them or if they can't communicate? What does that look like?
This is going to be obviously a harder one if the individual is nonverbal, but I mean, it's just like I mentioned with the tort claims in the past, the duty, breach, causation, and damages. In this situation, the damages will be the hardest portion to prove. And so when you're looking at the damages, you see that they talked about the individual now having PTSD, going to seek treatment. So I talk about how it can't just be an emotional harm, but the emotional harm now has to manifest itself into some physical type of harm. So if you're seeking treatment and you're not getting to rest and you're staying up all night, you're having nightmares, those are the types of things that you can point to as what my damages are, your damages are. But then, did you have a duty, and have you breached that duty? You can point to in this situation that IEP, that individualized that plan, that's supposed to be followed to the T. There's no exception, there's no deviation. They draw the roadmap for the teacher and everyone in the school. For any person that has an interaction with that student has to follow that IEP plan. And if they fail to, there are consequences, and that's why they list that as one of the reasons for their complaint as a rationale for the basis of them saying they've been wrong. Specifically, in this IEP, the kid was not supposed to be touched and given an opportunity to calm themselves down. You insert new teacher that doesn't understand or doesn't appreciate the ramifications of violating the IEP. Well, that's what I would point to in the complaint, and that's what they're listing here as the reasons for why they feel like they were violated. Also, failure to follow up on the IEP plan and failure to properly train staff. So in this regard, the nonverbal portion of the student does make it hard, but the facts will just be there. Like if the teacher wasn't aware, wasn't properly trained, wasn't properly brought up to speed on this kid's individual treatment plan, and they'll have to show, yeah, we had a meeting on 8/15 about this individual, this teacher knew it, going forward, if the school district failed to do that, this is pretty straightforward.
Khalif, a little bit of a curveball possibly, but with these school districts in both of these cases here, do you think there's any willingness when you have a school district to settle out of court rather than have this be prolonged, be in the headlines and news and have this repeatedly out there? Or is it easier to say, these are facts, this is what we're willing to offer, can we kind of put a bow on this?
Sometimes. So for the employment one, right, with the failure to promote and based on race, those ones you see the settlement oftentimes a lot sooner. When these ones that are involving kids, you do, but the school district will say that they're immune first. So they'll fight and say we're protected, at least in this school situation with the kid, that we're protected from the negligent actions of our employee. I've talked about that before, that respondeat superior, that typically an employer can be held liable for the actions of their employee if it's within the scope of their employment. Well, if this teacher was going outside of the scope of their employment, trying to restrain the student from leaving, well, I'm sure they have a resource officer and a number of other individuals that do this. And so I would point to, or if I'm the school district, I'm saying, hey, that wasn't in their job description. Their job description is to teach the kids. If I'm distancing myself from this situation, and then I'd say, listen, second, we're given some type of government immunity to protect us and insulate us from these types of claims as well. I think both of those arguments will be hard to go forward with proving at court, but that may make a settlement a little bit longer to get to because they at least have that in their bag.